Chief Justice, Justices, I represent the Hulkaminum Treaty Group, the HTG. The HTG represents 7,000 members of 6 Coast Salish First Nations from Vancouver Island, the Cowichan, Penelakut, Lake Cowichan, Halalt, Saminas, and Liaxin. We provided a condensed book, and at tab 1 there's a brief outline of our arguments. The HTG will focus these submissions on international law, dealing with Indigenous land rights, and the goal of reconciliation within the context of human rights. The HTG nations have a 100-plus year history of seeking reconciliation of the land question, starting in 1909 with a petition to the King of England. Recently, after participating in the BC Treaty process and frustrated at the lack of progress, HTG filed a petition with the Inter-American Commission on Human Rights in 2007. HTG alleged violations of their human rights pursuant to the Charter of the Organization of American States and the American Declaration on the Rights and Duties of Man. On the issue of admissibility and the exhaustion of domestic remedies, Canada argued that the BC Treaty process could provide HTG with a remedy. The Commission found, quote, since 15 years had passed, the BC Treaty process has demonstrated it is not an effective mechanism to protect the rights alleged. Canada also argued that HTG could pursue its claims in Canadian courts. The Commission rejected that argument, as the court decision cited by Canada on Aboriginal title had failed to, quote, provide any reasonable expectation of success. The Commission found, quote, Canadian jurisprudence has not obligated the state to set boundaries, to demarcate and record title deeds to lands of Indigenous peoples. And in the case of HTG, those remedies would not be effective. So the Commission ruled the petition was admissible with regard to alleged violations of Article 2, the right to equality, Article 3, religious freedom, Article 13, culture, Article 23, property of the American Declaration, and is currently considering the merits of the case. So for the first time, the land rights of Indigenous peoples in British Columbia is being dealt with within the international human rights legal system. The issue of the land rights of Indigenous peoples in other countries have been considered by the Inter-American human rights system through their commission and their court. The Inter-American Commission's seminal report entitled Indigenous and Tribal Peoples' Rights Over Their Ancestral Lands and Natural Resources, Norms and Jurisprudence of the Inter-American Human Rights System provides the norms and best practices for the human rights framework with respect to Indigenous land rights. HTG submits that this report should be considered relevant and persuasive and a helpful guide to the court in the interpretation of Section 35 rights. HTG submits that an interpretation of Section 35 Aboriginal rights that restricts title to small intensive use sites and not to a broader territory is inconsistent with international human rights law and would put Canada out of step with this international law. The Court of Appeal posed 3 questions to address the issue of reconciliation and Aboriginal rights with Crown or national sovereignty. The first question was, what type of rights are recognized? The appeal court refers to and apparently adopts the principle or doctrine of discovery. HTG submits that such doctrines are inconsistent with international law regarding human rights. Without question, the doctrine's most important principle, its central animating idea, is the principle of the superiority of European civilizations and the inferiority of Indigenous civilizations. Since the 1500s, this doctrine has resulted in language that describes Indigenous peoples as, for example, heathen, barbarian, untaught, uncivilized, rude, with no fixed abodes, semi-nomadic. and an obstacle to the progress and development of a superior form of civilization, the non-Indigenous nation state. These doctrines have influenced Canadian law and policy to validate either the denial of or the diminished status of Indigenous peoples' rights to lands and resources. What has impacted and continues to impact Indigenous peoples is not so much the idea of discovery, but the centuries of treating this domination, dehumanizing, and discriminatory us versus them approach to the legitimate exercise of Crown sovereignty. The UN Declaration preamble affirms that such doctrines are racist, legally invalid, morally condemnable, and socially unjust. And HTG would submit that doctrines of discovery, principles of discovery, should no longer be used to justify any further diminishment of Aboriginal rights in relation to lands and resources. Secondly, in terms of rights or title or rights, the appeal court found that an overly broad recognition of title is not conducive to reconciliation, and that small, intensively used sites with a larger area of Aboriginal rights would be sufficient to ensure their cultural security and continuity. The Commission, in their report, states that Indigenous peoples' territories are not limited to specific villages. Their use and occupancy extend beyond and include lands used for agriculture, hunting, and so forth, and are grounded in Indigenous legal cultures and ancestral ownership systems. That further, that Indigenous peoples must obtain title to their territory in order to guarantee its permanent use and enjoyment. In the HTG case on admissibility, the Commission in fact found that the BC legislation and consultation processes were not suitable in relation to the protection of ancestral burial places because those remedies are not, the purpose is not to comprehensively and protect ancestral lands and to recognize those property rights or any obligation of the state to provide any form of restitution. The second question put forward by the court was, how is the existence of title to be determined? The Commission, in their report, speak about evidence of historical occupation and use, as this court has done, but they also look at evidence of the adequacy of the territory for the development of the community. So there's a different element there. In terms of the protection to be afforded these rights, that states need to develop effective processes to demarcate and title, that the right to territory must have legal certainty, that Indigenous peoples must obtain title to their territories, and in order to guarantee its permanent use and enjoyment. Finally, the Court of Appeal suggested the need to seek out a practical compromise. HTG would submit that a narrow or an overly narrow recognition of title is also not conducive to reconciliation, that the negative impacts of small Indian reserves are evidence of this. The Commission states the lack of title and possession of ancestral lands is directly and causally linked to situations of extreme poverty, which trigger cross-cutting violations of human rights, including the right to life, that is the well-being and survival, economic and social rights, cultural identity and religious freedom, self-determination, and equality. HTG submits that there is also an implementation gap of the domestic and international law with respect to Aboriginal rights. As evidenced in the admissibility report in the HTG case, the Commission found that there were no effective domestic remedies to address the land issues that HTG was raising. It is submitted that current land claim litigation and treaty negotiation processes are too lengthy, too costly, too complicated, too inflexible and uncertain, and if the Court of Appeal's opinion is upheld, it will become even more so. Lastly, HTG submits that the only practical compromise is to construct a new paradigm. based on the promotion and protection of human rights by integrating the framework of international law into the domestic Aboriginal rights law to provide a way forward to achieving reconciliation through more effective processes.
Thank you very much.